Steph, what are the most common inquiries that you come across and why are the delays?
Okay, quite often, I think some of the problems can be, say, for example, somebody has a restriction on their title deeds that they don't know about. Particularly in a leasehold transaction, you'll need the consent of the landlord to sell.
Restriction on a title deed, just in layman's terms then, because I wouldn't, if I was a buyer, I wouldn't understand what that is.
A restriction on a title is just a note written on the title deeds to say, before you sell this house, you must give notice to this landlord.
Okay, got you.
So that needs to be investigated. The landlord needs to make sure we can find him. They can write to him, get that information, and allow that sale to go through. And particularly with the leasehold property, and there still are quite a lot of leasehold properties locally.
Yeah,
you'll need an LPE1, which is a landlord's information form, a landlord's information pack that is required. And landlords don't have the same sense of urgency as a seller or buyer in the transaction. So it can take weeks, months to even get one of those packs.
Sometimes they can't even be located.
And even when you do find the pack, further questions could come from that pack. Yeah. So again, pinning them down to get those questions answered is another time consuming.
Why sometimes you get a quote for buying a normal house and then you get a quote for buying a leasehold property, and obviously it's more expensive. That's because
there's a lot more work involved.
A lot more time.
Yeah, there's a lot more work involved. And the restrictions on the notes on the title means that the property cannot be sold without that information and getting that consent to the transaction. That's very time consuming.
Makes sense. Any other common inquiries that you sort of come across that delay the process?
I think boundary inquiries are quite often one, because quite often the deeds don't say who actually owns boundaries. You do get problems where there's, for example, a right of way over a rear passageway, a real alleyway at the property. People don't realise it's there. They fenced it off because they think that nobody uses it anymore and therefore it's ended. That's not technically true. That needs to be ended by a deed and in writing to end it. And you get some disputes like that can take some time to resolve, get to the bottom of.
Another thing that I always get a little bit, I can never remember it. So say you're looking at a house from the front, who's responsible for the left-hand boundary and the right-hand boundary, or does that even change?
I think that's a myth sometimes, really. People do think it's always the left-hand side or the right-hand side.
I've fallen for that then.
You tend to have to find the original document from when the property was built. There'll be the teeth facing marks to say on the plans who's entirely responsible for one. I think the general rule of thumb, if there's nothing in the title about it, if a boundary is joint, we normally say it's joint with you and the neighbour, it's jointly maintainable. Yeah. If it's one at the bottom, you've got nobody behind you, then that's probably your sole responsibility. Yeah. But that's only when there's nothing in the deeds to tell you otherwise.
Okay, got you. Yeah, because you get a lot of it where the fence is facing one side or the other. And I suppose you get cases where the back end of the fence is on their side, sort of thing.
And do you know when this question comes up the most? A windy weekend.
I'm sure.
That's the first call on the Monday morning. Yeah. Can you tell me who owns this fence, please?
Superb.